So Demetri is an associate at Kane Russell Coleman Logan, and he will be discussing legal considerations for y'all.
So my name's Demetri Economou. I'm a senior associate in the Labor and Employment Group at Kane Russell Coleman and Logan. We've got 90 lawyers in Houston and Dallas. It's a full-service law firm, and that's pretty much my marketing spiel that I'm going to do. What I'm going to be talking about today are some of the hiring considerations with respect to what's commonly known as ban the box. There were some comments earlier when I first came in the room about there being certain labor shortages in certain jobs. Have you considered people with questionable criminal history? Maybe, maybe not. Depending on where you recruit from, ban the box can be no deal or a really big deal. Here in Houston, it tends to be not such a big deal. But if you're recruiting or hiring nationwide, it can be very, very significant. Just to give you a little background about myself, I was a recruiter in an executive search firm before I went to law school. So I've been interfacing with HR leaders pretty much my entire career. Ban the box is a movement that started in 1998-ish. Started in Hawaii, which is one of the bluest of the blue places in the United States. But this has gained bipartisan support over the past year. Gained steam 2008. What happened in 2008? Major recession. Loss of jobs, people looking for jobs, and the same amount of people being incarcerated and coming out of incarceration. It applies to states, municipalities, that's counties, cities, states, and it almost is an application with respect to federal contractors, but that never really happened because it was implemented at the end of the last administration, and a lot of things that were implemented in the end of the last administration did not come to fruition now. Pushes off criminal background checks to a later point in the hiring process, typically after a conditional offer. Now, that is, in a lot of ways, counterintuitive to the way hiring should be done, because you should know about people when they're applying. But there are human factors behind this. It has, very good aims behind it, and it's to, one, increase the labor pool, and two, reducing recidivism is something that we would all support. We don't want to fill up our prisons with people that could be out working. On the other hand, you have to balance the needs of your company that you're working for or working with to protect people that are coming into their positions and to protect the people that are their customers. Basically, every ban the box situation pushes off the background check until after the conditional offer is given. In a lot of cases, the background check that is done is being marginalized. That means it's being limited. There's only certain things that you may be able to get access to through the background check. And that can be scary because I'm going to show you some pretty severe examples here. San Francisco, Philadelphia, and New York City. San Francisco, you hear about it all the time. They kind of do their own thing. That's an understatement in a lot of cases. But take a look at this. Think about if you were hiring in San Francisco. Could you do your job effectively with this kind of constraint? Somebody's been arrested for murder, and you can't ask about it. It's a pretty scary proposition. But nonetheless, that is what the goal is in San Francisco. Somebody ask a question here? Yeah.
I'm curious, can you repeat what you mean by that?
This is part of the marginalization of the background check, okay? So even if you are going to make a background check after you give a conditional offer, these are the things you can't look at.
Oh, wow.
It's
right?
the law today. It's the law today in those locations.
Right.
That's correct.
That is, I'm shocked.
But there is a difference between asking an applicant if you've been arrested versus convicted in an interview. You are allowed to ask somebody if you've ever been convicted of a crime. You're not allowed to ask somebody if you've ever been arrested, because potential being arrested and convicted are two very different things.
And so you're in
Right.
you're in San Francisco, though.
No,
You can,
I'm in New York.
okay. Well, we'll get down to you at number 3. So you're working in some places, you're working a recruiting job, you're hiring somebody, you're in San Francisco, you're in Philadelphia. 7+ years is not only ancient history, it's no history. It never happened. And so you're not finding out about these things until after the conditional offer is made and then further limited by the constraints of whatever city ordinance is in effect. Here's the contiguous United States. Remember, Hawaii is a ban-the-box state, so if you are hiring in Hawaii, I'm interested in a job. Anybody want to send me out there, I'd be happy to go. So these are your private employment ban-the-box states, okay? If you are hiring in one of these states, you have state laws passed by their legislature that are affecting all private hiring. These are your public employment ban-the-box states. Somebody here said they're working with prison systems. Okay, so you may be, are you guys contractors to the prison system or hiring directly in?
We are contracted to run the healthcare program, so we're a vendor for the state correctional system.
So your contract is directly with the state?
And the doctors work directly with us, yes.
Okay, so New Mexico, I think you said it was New Mexico, right?
We're in 16 states.
Okay, we'll take a look and see. You may have some concerns there, and you may have concerns as a vendor too. Those are all going to be state specific, yeah.
Our employees have to be security cleared to go into the facility, so it's not a condition. They can't be cleared to go in. They
Sure.
can't get
So
in.
you're
We're kind
the
of
industry that
stuck,
you're in
yeah.
has sort of fixed itself,
Yeah, right.
and that
Well, and
makes a
along
lot of
the
sense. Go
same
ahead.
lines, professional licensure requirements, require, that you're not going to be issued a medical degree or a nursing degree if you have a positive history of a whatever level felony or whatever it is.
Yeah.
How does that? I guess that's a little bit of protection because that's set on a state level as well.
That's true.
That would, and I guess the question is, what rule would apply in that kind of scenario?
So the licensure requirements are always going to apply.
Okay.
But think about if you're hiring for the entire system, the entire hospital. Not everybody that works there is going to have a license. You got people mopping the floors. You got people that have keys to all kinds of different rooms. That if you're in one of these states is going to be ban-the-box. And now here are where you also have municipalities. Yes, go ahead.
I was going to mention that one real life case we've seen is a nurse get pulled over for DWI, and somehow they get it to where it's expunged. They're not convicted. That's something you can't ask about in certain areas, right? Because you can't ask if they've been arrested. Only if they've been
Well,
convicted.
we're gonna get to expungements and petitions for non-disclosure. I have one opinion about it. Some people out here may share a different opinion, and I may be interested to hear your thoughts once we get to that section of the presentation. Thanks. So just to go back to this map real quick, you've got over 200 different jurisdictions in the United States that have adopted some form of ban-the-box. Vast majority of those are going to be cities and counties in large urban areas, as well as the states that are listed here. So you're not really having to worry about ban-the-box if you're working in Lufkin, but if you're working in Chicago, you might have to worry about ban-the-box. Philadelphia, New York, places we listed. Austin is the only large city in Texas that has any kind of city ban-the-box ordinance. It does apply to private employers. It is not being enforced very well at all right now. The last research that we did showed that there were only 3 complaints filed, and none of them had been followed up on. But nonetheless, it is a law affecting private employers that are doing hiring there. It pushes it off until after the conditional offer. And even after the conditional offer, you have to do something that's very typical of most ban-the-box jurisdictions, which is to perform some sort of individualized assessment. So the situation is this. You have offered employment conditionally based on a conditional offer of employment pending the background check. The background check comes back. You see that there is a crime or there's some sort of criminal activity on the record. You're now going to have to weigh that against the job needs, weigh the type of offense, punishment, and time served. Is it over Was it a 40-year sentence? Was it a 6-month sentence? Was it probation? And then the length of time and your job duties. Lumped into job duties, also you're going to consider things like employee and customer safety. If it's been some sort of a violent crime, that's a pretty easy call. But nonetheless, this is supposed to be done. Again, this law really doesn't have a lot of teeth right now. There's been attempts in Texas to prohibit ban-the-box ordinances. It was, for lack of a better word, pork on another bill. And when the legislator who was sponsoring the bill got called out on it, she withdrew the anti-ban-the-box part of the legislation. Go ahead.
How does that work with a right to work state? If the employer ultimately, if the employer ultimately decides employment or not, but you have that, then as long as the employer's not citing because of your criminal history, I'm not hiring you, what's a recourse? How does that work together?
You bring up an interesting point that some states actually make criminal history a protected class for the purpose of discrimination. I think New York State, you may be able to help me out here, Professor. The New York State, I think, is one that has a human rights law that actually makes discriminatory use of criminal history in making an adverse employment decision. And that is sort of talking about collateral damage of making decisions like that. That's one of them, and it actually gets in later in the presentation as well. City of Houston, City of San Antonio, these are for city employment. So again, if you're a city contractor, you're going to want to look and see if there are ordinances or part of your city contract that makes you do specific things. Same thing in Dallas and Travis County. So now we're encompassing all of the major metropolitan areas of Texas being affected by some sort of ban-the-box law, only Austin applying to private employers without any kind of entanglements with the county or city. And statewide ban-the-box it's not happening in Texas. Again, as I said in the beginning of the presentation, it's gaining bipartisan support because it has some very popular aims. When you talk about it just in terms of its roots, what is it based on? Why are we doing it? Everybody likes it. Nobody likes to fill up our jails. And people also like to help people get back on the right foot. Ban-the-box is, when you're doing national or international recruiting, ban-the-box can be extremely unwieldy. And you may contract with companies specifically to help you set up your online application portals so that they're asking the right questions to the right candidates based on what jurisdiction they are applying from and where the job is being applied in. These are some major companies that have just taken the step to ban the box themselves. They don't have to worry about any of this anymore, but they're moving their own goalposts in terms of when they're going to consider criminal history to after the conditional offer stage. Good or bad, it does make hiring a little bit easier on them because they don't ever have to worry about getting sideways from a public affairs point of view in one of these jurisdictions that does have ban the box. That's really bad press if you look like you're trying to exclude an entire portion of the population, which is a large portion of the population. I want to show you something interesting if I can just go back to this map real quick. There's not really, and I found this interesting when I put it up, is that the highest percentage of incarcerations in the United States are in the South. And those are typically not your ban-the-box states. I found that interesting. I haven't been able to figure out why there's not a correlation, because there's obviously a large demographic there that would be in favor of ban-the-box. All right, now we're going to get to expunctions and petitions for non-disclosure. This is here in Texas. You've got two ways of sealing records. You have the expunction and the petition for non-disclosure. The expunction, when it happens, if all the correct steps are taken, really serves to make the thing disappear. Not only does the applicant or the employee not have to talk about it, this is my reading of the law, not have to talk about it, they don't have to talk about it in a court of law either. The expunction is the magic bullet that gets rid of that offense. For that reason, it is limited, there's statutory waiting periods, and you do have to go through a court procedure. For an expunction, you pretty much need a lawyer to do this for you. So let's talk about who can access it. Most governmental entities that obtain criminal records cannot even access expunged records. Certainly not private employees and not background check companies. We'll see in a minute that background check companies are regulated pretty heavily on the sanctity of expunged and non-disclosed information. These are the categories of offenses that cannot be expunged. So on most offenses, they cannot be expunged because this is going to be the result of most criminal activity in our court systems. It's going to be a conviction, a deferred adjudication, or probation. You're only offered pretty much two options. Go to trial or take a deal. The DA very rarely comes to you and says, we're just not interested in your case anymore. Okay, so I've highlighted the key words here in the Code of Criminal Procedure: use for any purpose, applications, decisions, adverse employment decisions. That is any purpose. So you're going to fall within that if you make this decision. Petitions for non-disclosure are like expunction, but they're available for a much larger class of criminal activity. Am I doing on time?
Here, I have a question.
Sure, go ahead.
We have what we call national practitioner database, right? We have those they sometimes can keep information that may have already been established. So in those cases, if a facility has access to that, you're saying they can't act on it?
They should not act on it. They should never have it in the first place. And these clearinghouses have a 3 strikes you're out rule. If they disseminate expunged or non-disclosed information 3 times, they lose access for a period of 1 year. Put them out of business. They would not be operating with no access for a period of 1 year. So, yeah, my general legal information would be to not act on things that you know have been expunged or non-disclosed, because you really should not have had them in the first place. It goes through the same basic process: petition, order, and giving notice to all the different agencies that collect information. These are the kind of things you don't have to worry about being non-disclosed, because they can't be non-disclosed. So if there's one of these that is on the criminal record, you're going to know about it. And if you've had one of these, I'm sure you've jumped out of your chair the moment that you saw it. Somebody had one of these on this list? I have.
Not personally.
What? Oh, not personally? I've got 2 or 3 of these on mine.
We've had we hired a traveler, in my experience. We had hired a traveling nurse. 2 nightmares. One of them was a sex offender, and none of the printout for the background check ever came through until after the person was already hired into our facility. And the other one said she was her background check, she was hired before the background check came, and she never even had a nursing license. Okay. Oh yeah.
What was the timing like on the first one, on the first sex offender?
Oh, really?
I mean, did the conviction happen after she was hired or before?
It was a man. It was a male, and it was on his record. And
Should have come through on the background check.
Yeah, it didn't until we never got the physical background check. The traveling company that we hired them from, never checked the background check and never sent it to us
Well, there's your problem.
after the person was already on site. Yeah, and he worked 3 shifts. So we let him cut our ties.
It's a pretty scary situation. Go ahead.
Sent him home.
We had a situation where we were looking at a candidate coming into our hospital as a perm candidate, and we always look through nurses just to verify their licensures. And I didn't realize that all of the I'll just talk loud. I didn't realize that not all states are associated through nurses. So So we had done a background check on this individual. The background came back okay with no disciplinary actions on their licensure. And then once we came closer to hiring that person on site, then you recheck the background again. And it just so happens that at that time, the state, I think it was Pennsylvania, decided to join the Nurses Association, and you were able to. So all states don't have to take advantage of posting their information on nurses. So,
And this employee was in already.
well, no, the employee did not end up coming in. We check the background first. If there's no violations or any concerns, then we move forward. If there are concerns, we would take it to our higher ups to determine if we're going to move forward with that candidate. And then, but it was in the hiring process that we re-looked at this person's licensure, and it just so happens that a specific state just had signed up on nurses, and you were able to see all of these disciplinary actions that had been held against them, to include injury to elderly people, disabled, medication issues. So just keep in mind when you are doing those background checks on nurses especially, Nurses isn't the only site that you need to be looking at. You need to be looking at your individual state sites as well as to where they're coming from. And if I would have done that in the beginning, then I would have been able to see that there was obviously some sort of pending case. That was another thing too. There was a pending case against this person who was hoping to come on board with us. So we kind of were able to jump the gun and not move forward, but it was really scary to find out that it was a pending case and it didn't come up until after the fact.
And to address both of y'all's points, we're going to talk in a second about continuous background checking. That's background checking after employment. That's not necessarily super common, but it's something that can be done if you've got the right consent on the front end. This is what I was talking about, the 3 strikes you're out rule for companies that are clearinghouses for records. Go ahead. Okay. I don't think you should be using expunged or petition for non-disclosure information if you find out about it. Unless it's told to you by the applicant. And that happens more than you would think. In Texas, you may use this information. In other states, we were talking about New York earlier, it's a creation of a protected class, just like race, sex, religion, national origin. Texas, of course, does not have that protected class for criminals. There is a remote chance you could back your way into a Title VII claim because of the way that the incarcerated demographic turns out to be. Those turn out to be protected classes under Title VII. So there's cases where the claim is cognizable. It's not necessarily a winner, but it can get past a federal motion to dismiss. All right, continuous screening. Most companies are doing this once when the person is hired. And then they might work for another 25 years without ever having another background check. What do you do if a little birdie tells you, I think something might have happened last weekend? Do you want to act on the rumor? Or do you want to go have another background check run so that you actually have something concrete to act on? You can do this, but you still have to have consent under the FCRA. If your consent is evergreen, that means it's conspicuous that it's going to be used for the initial background check, the pre-hire background check, and subsequent background checks. It's an evergreen consent. It lasts forever. I would be very, very specific about the language that's included there. But you won't have to go back to the employee for another signature when the little birdie tells you that something may have happened last weekend. Yes?
I'm from New York.
Yes, ma'am. Uh-huh. And so you have used it in post-hire background checks?
Yep.
California is the only one that you might worry a little bit about this. The law can be read one of 2 ways. The law can be read 2 ways, I'm sorry.
Yeah, is there a
Go ahead.
recommendation on that? I mean, is there some kind of guidance on
On evergreen consents?
well, not necessarily evergreen consents, but assessing criminal backgrounds on some kind of frequency?
Oh, no, I mean, it's going to be on an employer by employer basis and really an industry by industry basis. But what the evergreen consent allows you to have is the flexibility where if you need to go get a background check, or if you even want to set up a procedure where you're going to have random background checks every 5 years or so, you don't have to go get the signature and freak people out again that they're being investigated. Yes,
So
ma'am.
the question is, if you did have to like get their consent and have to make it aware that you needed to do that, if a person really went and committed a crime, are they going to actually give you consent to run their background?
That's
Probably not.
probably not.
Well,
That's
that would be
that's the point.
conditions for employment too. I mean, if they don't consent potentially.
That's true. But, I mean, we want to be able to, I'm not trying to be the police here, but you want to be able to nail somebody if they have committed a crime and they're not reporting it to you.
I mean,
And so
that
that's,
would probably be different than like doing a random drug test or something.
It is
A lot
different.
of people do drug screens when they first get hired into a job, but
Yeah.
then they may go and, do some kind of drug or something, and then that drug screen may not necessarily be done unless something is warranted or their behavior is suspicious and there's a reason for them to then go and do a drug screen. So I would think the same, would be the case in this situation, but a person is not going to go commit a crime and be like, oh yeah, you can go and run my background again. Because they
You're
know
right.
it's gonna.
I'm getting the hook here. I really appreciate HR Maximizer, Ascend, HR, everybody for coming out. Thank you.